Chapter 9. Registration, Responsibilities and Oversight of Self-Regulatory Organizations. SEC 430. The Commissioner shall have the power to register as a self-regulatory organization, or otherwise grant licenses, and to regulate, supervise, examine, suspend, or otherwise discontinue, as a condition for the operation of organizations whose operations are related to or connected with the insurance market, such as, but not limited to, associations of insurance companies, whether life or non-life, reinsurers, actuaries, agents, brokers, dealers, mutual benefit associations, trusts, rating agencies, and other persons regulated by the Commissioner, which are engaged in the business regulated by this code. The Commissioner may prescribe rules and regulations which are necessary or appropriate in the public interest or for the protection of investors to govern self-regulatory organizations and other organizations licensed or regulated pursuant to the authority granted hereunder, including, but not limited to, the requirement of cooperation within and among all participants in the insurance market to ensure transparency and facilitate exchange of information. SEC 431. An association cannot be registered as a self-regulatory organization unless the Commissioner determines that a. The association is so organized and has the capacity to be able to carry out the purposes of this code and to comply with, and to enforce compliance by its members and persons associated with its members, with the provisions of this code, the rules and regulations thereunder, and the rules of the association. b. The rules of the association, notwithstanding anything in the Corporation Code to the contrary, provide the following. 1. Qualifications and the disqualifications on membership of the association. 2. A fair representation of its members to serve on the board of directors of the association and the administration of its affairs, and that any natural person associated with a juridical entity that is a member shall also be deemed to be a member for this purpose. 3. The president of the association and at least two independent directors as members of the board of directors of the association. 4. Equitable allocation of reasonable dues, fees, and other charges among members and other persons using any facility or system which the association operates or controls. 5. The prevention of fraudulent and manipulative acts and practices to protect the insuring public and the promotion of just and equitable principles of business. 6. Members and persons associated with its members subject to discipline for violation of any provision of this code, the rules or regulations thereunder, or the rules of the association. 7. Fair procedure for the disciplining of members and persons associated with members, and 8. The prohibition or limitation of access to services offered by the association or a member thereof. SEC 432. A self-regulatory organization may examine and verify the qualifications of an applicant to become a member in accordance with procedures established by the rules of the association. A self-regulatory organization shall deny membership or condition the membership of an entity, if it does not meet the standards of financial responsibility, operational capability, training, experience, or competence that are prescribed by the rules of the association, or has engaged, and there is a reasonable likelihood it will again engage, in acts or practices inconsistent with just and equitable principles of fair trade. A self-regulatory organization may deny membership to an entity not engaged in a type of business in which the rules of the association require members to be engaged. SEC 433. Upon the filing of an application for registration as a self-regulatory organization under this title, the Commissioner shall have 90 days within which to either grant registration or institute a proceeding to determine whether registration should be denied. In the event proceedings are instituted, the Commissioner shall have 270 days within which to conclude such proceedings, at which time he shall, by order, grant or deny such registration. SEC 434. Every self-regulatory organization shall comply with the provisions of this code, the rules and regulations thereunder, and its own rules, and enforce compliance therewith by its members, persons associated with its members or its participants, notwithstanding any provision of the Corporation Code to the contrary. SEC 435. Each self-regulatory organization shall submit to the Commissioner for prior approval any proposed rule or amendment thereto, together with a concise statement of the reason and effect of the proposed amendment. Within 60 days after submission of a proposed amendment, the Commissioner shall, by order, approve the proposed amendment. Otherwise, the same may be made effective by the self-regulatory organization. In the event of an emergency requiring action for the protection of the insuring public, a self-regulatory organization may put a proposed amendment into effect summarily, provided, however, that a copy of the same shall be immediately submitted to the Commissioner. The Commissioner is further authorized, if after making appropriate request in writing to a self-regulatory organization that such organization effect on its own behalf specified changes in its rules and practices and, after due notice and hearing, it determines that such changes have not been effected, and that such changes are necessary, by rule or regulation or by order, may alter, abrogate or supplement the rules of such self-regulatory organization insofar as necessary or appropriate to effect such changes in respect of such matters as a. Safeguards in respect of the financial responsibility of members and adequate provision against the evasion of financial responsibility through the use of corporate forms or special partnerships. B. The supervision of market practices. C. The manner, method, and place of soliciting business. D. The fixing of reasonable rates of fees, interest, listing, and other charges, but not rates of commission, and self-regulatory organization, and E. The supervision, auditing and disciplining of members. In addition to the general powers of the Commissioner over the entities under supervision, the Commissioner, after due notice and hearing, is authorized, in the public interest and to protect the insuring public. 1. To suspend for a period not exceeding 12 months or to revoke the registration of a self-regulatory organization, or to censure or impose limitations on the activities, functions, and operations of such self-regulatory organization, if the Commission finds that such a self-regulatory organization has willfully violated or is unable to comply with any provision of this code or of the rules and regulations thereunder, or its own rules, or has failed to enforce compliance therewith by a member of, person associated with a member, or a participant in such self-regulatory organization. 2. To expel from a self-regulatory organization any member thereof or any participant therein who is found to have willfully violated any provision of this code or suspend for a period not exceeding 12 months for violation of any provision of this code or any other law administered by the Commission, or the rules and regulations thereunder, or effected, directly or indirectly, any transaction for any person who, such member or participant had reason to believe, was violating in respect of such transaction any of such provisions, and 3. To remove from office or censure any officer or director of a self-regulatory organization if it finds that such officer or director has violated any provision of this code, any other law administered by the Commissioner, the rules or regulations thereunder and the rules of such self-regulatory organization, or has abused his authority, or without reasonable justification or excuse has failed to enforce compliance with any of such provisions. SEC 436. A. A self-regulatory organization is authorized to discipline a member of or participant in such self-regulatory organization, or any person associated with a member, including suspending or expelling such member or participant, or suspending or barring such person from being associated with a member, if engaged in acts or practices inconsistent with just and equitable principles of fairness or in willful violation of any provision of this code, any other law administered by the Commission, the rules or regulations thereunder, or the rules of the self-regulatory organization. In any disciplinary proceeding by a self-regulatory organization, other than a summary proceeding pursuant to paragraph B of this section, the self-regulatory organization shall bring specific charges, provide notice to the person charged, afford the person charged with an opportunity to defend against the charges, and keep a record of the proceedings. A determination to impose a disciplinary sanction shall be supported by a written statement of the offense, a summary of the evidence presented and a statement of the sanction imposed. b. A self-regulatory organization may summarily 1. Suspend a member, participant, or person associated with a member who has been or is expelled or suspended from any other self-regulatory organization, or 2. Suspend a member who the self-regulatory organization finds to be in such financial or operating difficulty that the member or participant cannot be permitted to continue to do business as a member with safety to investors, creditors, other members, participants, or the self-regulatory organization, provided that the self-regulatory organization immediately notifies the Commission of the action taken. Any person aggrieved by a summary action pursuant to this paragraph shall be promptly afforded an opportunity for a hearing by the Association in accordance with the preceding paragraph. The Commissioner, by order, may stay a summary action on his own or upon application by any person aggrieved thereby, if the Commissioner determines summarily or after due notice and hearing, which hearing may consist solely of the submission of affidavits or presentation of oral arguments, that a stay is consistent with the public interest and the protection of the insuring public. c. A self-regulatory organization shall promptly notify the Commission of any disciplinary sanction on any member thereof or participant therein, any denial of membership or participation in such organization, or the imposition of any disciplinary sanction on a person associated with a member or a bar of such person from becoming so associated. Within 30 days after such notice, any aggrieved person may appeal to the Commissioner from, or the Commissioner on its own motion within such period, may institute review of, the decision of the self-regulatory organization, at the conclusion of which, after due notice and hearing, which may consist solely of review of the record before the self-regulatory organization, the Commissioner shall affirm, modify, or set aside the sanction. In such proceeding, the Commissioner shall determine whether the aggrieved person has engaged or omitted to engage in the acts and practices as found by the self-regulatory organization, whether such acts and practices constitute willful violations of this code, any other law administered by the Commission, the rules or regulations thereunder, or the rules of the self-regulatory organization as specified by such organization, whether such provisions were applied in a manner consistent with the purposes of this code, and whether, with due regard for the public interest and the protection of investors, the sanction is excessive or oppressive. Chapter X. The Insurance Commissioner. Title L. Administrative and Adjudicatory Powers. SEC 437. The Insurance Commissioner shall be appointed by the President of the Republic of the Philippines for a term of 6 years without reappointment, and who shall serve as such until the successor shall have been appointed and qualified. If the Insurance Commissioner is removed before the expiration of his term of office, the reason for the removal must be published. The Insurance Commissioner shall have the duty to see that all laws relating to insurance, insurance companies, and other insurance matters, mutual benefit associations, and trusts for charitable uses are faithfully executed, and to perform the duties imposed upon him by this code, and shall, notwithstanding any existing laws to the contrary, have sole and exclusive authority to regulate the issuance and sale of variable contracts as defined in Section 238 hereof, and to provide for the licensing of persons selling such contracts, and to issue such reasonable rules and regulations governing the same. The Commissioner may issue such rulings, instructions, circulars, orders, and decisions as may be deemed necessary to secure the enforcement of the provisions of this code, to ensure the efficient regulation of the insurance industry in accordance with global best practices, and to protect the insuring public. Except as otherwise specified, decisions made by the Commissioner shall be appealable to the Secretary of Finance. In addition to the foregoing, the Commissioner shall have the following powers and functions. A. Formulate policies and recommendations on issues concerning the insurance industry, advise Congress and other government agencies on all aspects of the insurance industry, and propose legislation and amendments thereto. B. Approve, reject, suspend, or revoke licenses or certificates of registration provided for by this code. C. impose sanctions for the violation of laws and the rules, regulations, and orders issued pursuant thereto. D. Prepare, approve, amend, or repeal rules, regulations and orders, and issue opinions and provide guidance on and supervise compliance with such rules, regulations, and orders. E. Enlist the aid and support of, and/or deputize any and all enforcement agencies of the government in the implementation of its powers and functions under this code. F. Issue cease and desist orders to prevent fraud or injury to the insuring public. G. Punish for contempt of the Commissioner, both direct and indirect, in accordance with the pertinent provisions of and penalties prescribed by the rules of court. H. Compel the officers of any registered insurance corporation or association to call meetings of stockholders or members thereof under its supervision. I. Issue subpoena duces tecum and summon witnesses to appear in any proceeding of the Commission and, in appropriate cases, order the examination, search, and seizure of all documents, papers, files and records, tax returns, and books of accounts of any entity or person under investigation as may be necessary for the proper disposition of the cases before it, subject to the provisions of existing laws. J. Suspend or revoke, after proper notice and hearing, the license or certificate of authority of any entity or person under its regulation, upon any of the grounds provided by law. K. Conduct an examination to determine compliance with laws and regulations if the circumstances so warrant as determined by appropriate rules and regulations. L. Investigate not oftener than once a year from the last date of examination to determine whether an institution is conducting its business on a safe and sound basis, provided that the deficiencies/irregularities found by or discovered by an audit shall be immediately addressed. M. Inquire into the solvency and liquidity of the institutions under its supervision and enforce prompt corrective action. N. To retain and utilize, in addition to its annual budget, all fees, charges and other income derived from the regulation of insurance companies and other supervised persons or entities. O. To fix and assess fees, charges and penalties as the Commissioner may find reasonable in the exercise of regulation, and P. Exercise such other powers as may be provided by law as well as those which may be implied from, or which are necessary or incidental to the express powers granted the Commission to achieve the objectives and purposes of this code. The Commission shall indemnify the Commissioner, Deputy Commissioner, and other officials of the Commission, including personnel performing supervision and examination functions, for all costs and expenses reasonably incurred by such persons in connection with any civil or criminal actions, suits, or proceedings to which they may be made a party to by the reason of the performance of their duties and functions, unless they are finally adjudged in such actions, suits, or proceedings to be liable for negligence or misconduct. In the event of settlement or compromise, indemnification shall be provided only in connection with such matters covered by the settlement as to which the Commission is advised by external counsel that the persons to be indemnified did not commit any negligence or misconduct. The costs and expenses incurred in defending the aforementioned action, suit, or proceeding may be paid by the Commission in advance of the final disposition of such action, suit or proceeding upon receipt of an undertaking by or on behalf of the Commissioner, Deputy Commissioner, officer, or employee to repay the amount advanced should it ultimately be determined by the Commission that the person is not entitled to be indemnified. SEC 438. In addition to the administrative sanctions provided elsewhere in this code, the Insurance Commissioner is hereby authorized, at his discretion, to impose upon insurance companies, their directors, and/or officers and/or agents, for any willful failure or refusal to comply with, or violation of any provision of this code, or any order, instruction, regulation, or ruling of the Insurance Commissioner, or any commission or irregularities, and/or conducting business in an unsafe or unsound manner. As may be determined by the Insurance Commissioner, the following: A. Fines not less than 5,000 pesos, P5,000.00, and not more than 200,000 pesos, P200,000.00, and B. Suspension, or after due hearing, removal of directors and/or officers and/or agents. SEC 439. The Commissioner shall have the power to adjudicate claims and complaints involving any loss, damage, or liability for which an insurer may be answerable under any kind of policy or contract of insurance, or for which such insurer may be liable under a contract of suretyship, or for which a reinsurer may be sued under any contract of reinsurance it may have entered into, or for which a mutual benefit association may be held liable under the membership certificates it has issued to its members. Where the amount of any such loss, damage, or liability, excluding interest, cost and attorney's fees, being claimed or sued upon any kind of insurance, bond, reinsurance contract, or membership certificate does not exceed in any single claim 5 million pesos, P5,000,000.00. The power of the Commissioner does not cover the relationship between the insurance company and its agents/brokers but is limited to adjudicating claims and complaints filed by the insured against the insurance company. The Commissioner may authorize any officer or group of officers under him to conduct investigation, inquiry, and/or hearing and decide claims, and he may issue rules governing the conduct of adjudication and resolution of cases. The rules of court shall have suppletory application. The party filing an action pursuant to the provisions of this section thereby submits his person to the jurisdiction of the Commissioner. The Commissioner shall acquire jurisdiction over the person of the impleaded party or parties in accordance with and pursuant to the provisions of the rules of court. The authority to adjudicate granted to the Commissioner under this section shall be concurrent with that of the civil courts, but the filing of a complaint with the Commissioner shall preclude the civil courts from taking cognizance of a suit involving the same subject matter. Any decision, order, or ruling rendered by the Commissioner after a hearing shall have the force and effect of a judgment. Any party may appeal from a final order, ruling, or decision of the Commissioner by filing with the Commissioner within 30 days from receipt of copy of such order, ruling, or decision a notice of appeal to the Court of Appeals in the manner provided for in the Rules of Court for appeals from the Regional Trial Court to the Court of Appeals. For the purpose of any proceeding under this section, the Commissioner, or any officer thereof designated by him is empowered to administer oaths and affirmation, subpoena witnesses, compel their attendance, take evidence, and require the production of any books, papers, documents, or contracts or other records which are relevant or material to the inquiry. A full and complete record shall be kept of all proceedings had before the Commissioner, or the officers thereof designated by him, and all testimony shall be taken down and transcribed by a stenographer appointed by the Commissioner. In order to promote party autonomy in the resolution of cases, the Commissioner shall establish a system for resolving cases through the use of alternative dispute resolution. Title II. Fees and other sources of funds. SEC 440. A. For the issuance or renewal of certificates of authority, licenses and certificates of registration, pursuant to pertinent provisions of this code, the Commissioner shall collect and receive fees which shall be not less than the following. For each certificate of authority issued to an insurance company doing business in the Philippines, 200 pesos, P200.00. For each special certificate of authority issued to a servicing insurance company, 100 pesos, P100.00. For each license issued to a general agent of an insurance company, 50 pesos, P50.00. For each license issued to an insurance agent, 25 pesos, P25.00. For each license issued to an agent of variable contract policy, 25 pesos, P25.00. For each license issued to an insurance broker, 100 pesos, P100.00. For each license issued to a reinsurance broker, 100 pesos, P100.00. For each license issued to an insurance adjuster, 100 pesos, P100.00. For each certificate of registration issued to an actuary, 50 pesos, P50.00. For each certificate of registration issued to a resident agent, 50 pesos, P50.00. For each license issued to a rating organization, 100 pesos, P 100.00. For each certificate of registration issued to a non-life company underwriter, 50 pesos, P 50.00. For each license issued to a mutual benefit association, 10 pesos, P 10.00. For each certificate of registration issued to a trust for charitable uses, 10 pesos, P 10.00. All certificates of authority and all other licenses, as well as all certificates of registration, issued to any person, partnership, association, or corporation under the pertinent provisions of this code for which no expiration date has been prescribed, shall expire on the last day of December of the third year from its issuance and shall be renewed upon application therefor and payment of the corresponding fee, if the licensee or holder of such license or certificate is continuing to comply with all the applicable provisions of existing laws, and of rules, instructions, orders, and decisions of the Commissioner. B. For the filing of the annual statement referred to in Section 229, the Commissioner shall collect and receive from the insurance company so filing a fee of not less than 500 pesos, P 500.00 provided, that a fine of not less than 100 pesos, P 100.00, shall be imposed and collected by the Commissioner for each week of delay, or any fraction thereof, in the filing of the annual statement. For the filing of annual statement referred to in Section 413, the Commissioner shall collect and receive from the Mutual Benefit Association so filing a fee of not less than 10 pesos, P 10.00 provided, that a fine of not less than 10 pesos, P 10.00, shall be imposed and collected by the Commissioner for each week of delay, or any fraction thereof, in the filing of the annual statement. C. For the examination prescribed in Section 253, the Commissioner shall collect and receive fees according to the amount of its total assets, in the case of a domestic company, or of its assets in the Philippines, in the case of a foreign company, not less than the amount as follows. 1. 2 million pesos or more but less than 4 million pesos, 400 pesos, P 400.00. 2. 4 million pesos or more but less than 6 million pesos, 800 pesos, P 800.00. 3. 6 million pesos or more but less than 8 million pesos, 1,200 pesos, P 1,200.00. 4. 8 million pesos or more but less than 10 million pesos, 1,600 pesos, P 1,600.00. 5. 10 million pesos or more, 2,000 pesos, P 2,000.00. Provided, that if the said examination is made in places outside the metropolitan Manila area, besides these fees, the Commissioner shall require of the company examine the payment of the actual and necessary traveling and subsistence expenses of the examiner or examiners concerned. For the examination prescribed in Section 412, the Commissioner shall collect and receive a minimum fee of not less than 100 pesos, P 100.00, from the Mutual Benefit Association examined, provided, that if such association has total assets of more than 100,000 pesos, P 100,000.00, an additional fee of not less than 10 pesos, P 10.00, for every 50,000 pesos, P 50,000.00, in excess thereof shall be imposed. D. For the filing of an application to withdraw from the Philippines under Title 18, the Commissioner shall collect and receive from the foreign company so withdrawing a fee of not less than 1,000 pesos, P 1,000.00. E. The Commissioner may fix and collect fees or charges for documents, transcripts, or other materials which may be furnished by him not in excess of reasonable cost. SEC 441. The Commissioner, in accordance with the rules and regulations of the Department of Budget and Management and other relevant regulatory agencies, shall source the salary, allowances, and other expenses from the retained amount of the fees, charges, penalties and other income from the regulation of insurance companies and other covered persons and entities, and from the insurance fund, which is created out of the proceeds of taxes on insurance premiums mentioned in Section 255 of the National Internal Revenue Code, as amended. Miscellaneous Provisions. SEC 442. Any person, company, or corporation subject to the supervision and control of the Commissioner who violates any provision of this code, for which no penalty is provided, shall be deemed guilty of a penal offense, and upon conviction be punished by a fine not exceeding 200,000 pesos, p. 200,000.00, or imprisonment of 6 months, or both, at the discretion of the court. If the offense is committed by a company or corporation, the officers, directors, or other persons responsible for its operation, management, or administration, unless it can be proved that they have taken no part in the commission of the offense, shall likewise be guilty of a penal offense, and upon conviction be punished by a fine not exceeding 200,000 pesos, p. 200,000.00, or imprisonment of 6 months, or both, at the discretion of the court. SEC 443. All criminal actions for the violation of any of the provisions of this code shall prescribe after 3 years from the discovery of such violation, provided that such actions shall in any event prescribe after 10 years from the commission of such violation. SEC 444. Any person, partnership, association, or corporation heretofore authorized, licensed or registered by the Commissioner shall be deemed to have been authorized, licensed, or registered under the provisions of this code and shall be governed by the provisions thereof, provided, however, that where any such person, partnership, association, or corporation is affected by the new requirements of this code, said person, partnership, association or corporation shall, unless otherwise herein provided, be given a period of 1 year from the effectivity of this code within which to comply with the same. SEC 445. Transitory Provision. Renewal of existing licenses, certificates of authority or accreditation which will expire on June 30, 2013 shall be valid until December 31, 2015. Thereafter, renewal shall be filed on the last day of December every third year following the date of expiry of the license, certificate of authority or accreditation. SEC 446. Repealing Clause. Except as expressly provided by this code, all laws, decrees, orders, rules and regulations or parts thereof, inconsistent with any provision of this code shall be deemed repealed, amended, or modified accordingly. SEC 447. Separability Clause. If any provision of this code or any part hereof be declared invalid or unconstitutional, the remainder of the law or other provisions not otherwise affected shall remain valid and subsisting. SEC 448. This code shall take effect 15 days following its publication in a newspaper of general circulation. Approved Aug. 15, 2013.